Hello everyone. Today in the newspaper there was some news that what is the contention of Coal India Limited versus Competition Commission of India (CCI). This was in news recently. What exactly is this? What is the dispute between Competition Commission and why Coal India has lost its legal battle in the Supreme Court against Competition Commission of India? Welcome to thematic discussion. This is Dhanu's Do It Now channel. Uh, this is mainly in the UPSC perspective. For UPSC prelims and mains, this topic is really important. Let's quickly discuss what it is. So this is the topic. Competition Commission of India on June 15th, that is 6 days back, the Supreme Court has held that Competition Coal India Limited has to pay the compensation of rupees around 591 crores to Competition Commission of India for breaking down the Monopolies Act or for breaking down Competition Commission rules. Now, what exactly is the argument here? In order to understand this, we have to understand what is Competition Commission of India, what is Competition Commission of India Act, what is Coal India's case altogether. Let's start with what is Coal India Limited. Coal India Limited is a public sector company. We all know this. It is a public sector company. Now, recently, this Coal India Limited company, what it does is it has made some agreements with thermal power plants who are generating thermal electrical energy from coal. So as per this agreement, Coal India Limited has to supply coking coal. This is previous year UPSC question. What is coking coal? Coking coal to the electricity plants, and through this the electricity plants will use this coking coal and they will generate electricity. This is the first thing that you have to understand. Now if you look at the coal reserves in India, in the year 1973, Government of India under its nationalization plan has nationalized coal mines. So this was the year of 1973. We all know this. This was the time of Srimati Indira Gandhi. She has also nationalized many things like nationalization of banks in 1969. Nationalization of banks, second act was passed somewhere around 1978. So like this nationalization of the things has happened and coal mines were nationalized. Now what do I mean by coal nationalization? Coal nationalization means it aims to transfer the ownership rights of coal mines to the government of India. No private player can own the coal mines. This was the thing. Why? Coal is a very limited resource and very important resource. So government of India wants to exercise its control under this. However, subsequently the act was amended in the year 1993 as a form of LPG reforms. Now this coal mines was open to private sector and private sector captive mining is allowed. What is captive mining? An industry which is using coal for its use. So they can go, they can participate in this coal mining auctions and they can get it. So this was the thing. Through this, what Government of India wanted to do is coal is open to private sector or coal mining is open to private sector. It is not exclusive reserved for Coal India. Coal India was until 1993 it was exclusively reserved or monopoly was present with Coal India. Now the private agencies after 1993 has the share in this coals. So today coal is not monopolized, rather it should work on competition. Whoever is good at the competition, they will go, they will bid the argument or they will bid the mines and they will extract the things. So this is called competition. So monopolies restrict to trade practices. If you look at this, monopolies restrict to trade practices, you have to understand one thing, that in India initially there was Monopoly Restrict to Trade Practices Act. This was replaced by Competition of Commission of India Act. In order to overlook this Competition Commission of India Act, Competition Commission of India was a statutory body was organized by the Government of India. This do not allow monopoly of any company. Hence today all the companies have to go for competition and monopoly is restricted. So for Coal India, under Competition Commission of India Act, it doesn't enjoy monopoly after 1993. It is coming under competition just like with any private sector. Now, who has asked to replace MRTP Act with Competition Commission of India Act? It was Raghavan Committee. Very important. Raghavan Committee has recommended for the changing of MRTP Act with Competition Commission of India Act, and Government of India has done this based on this act. So Monopoly Restrictive Trade Practices Act of 1961 was replaced with Competition Commission of India Act 2002, and this, in order to overlook this, Competition Commission of India was launched. So it is a statutory body, obviously, because Competition Commission of India Act has launched this, and it has 6 members in its team. So it functions as a quasi-judicial body. So these are the things that you have to understand by Competition Commission of India. So now what is the case related to? The case is related to Coal India has said that now Competition Commission of India argued before the Supreme Court that while making deals by Coal India with these thermal power plants, they have followed an opaque manner of bidding. So whenever you are bidding, the contract has to be transparent, but they have not followed this. They have followed opaque. The second thing is low quality of coal was supplied to the power plants rather than supplying high quality. As a result, they have said that these fellows has broken down the norms and they have to pay a fine of 591 crores. In return, Coal India has said that under Nationalization of Mines Act, Coal India has ultimate authority. This public sector unit has ultimate authority to make deals with anyone. No authority can say that whether the deal has to be opaque or whether it has to be transparent. Or it is also saying that we have done it for the common good. In the interest of public, we have followed it. What Competition Commission of India has responded to this is, Competition Commission of India responded, today Coal India doesn't come under Monopoly Act, it should be under the so-called Competition Act. Hence, state monopoly could not be allowed in this case. So Coal India doesn't have anything. So Coal India's argument was, it went with the Nationalization Act, but the thing is very clear, after 1993, coal mines were open to competition. So operation of coals outside the purview of the Competition Act. They said that Competition Act doesn't apply here. Competition Commission of India said that it applies here. The reason is absolutely in favor of CCI. And what the Supreme Court said, whatever the argument that Coal India did is wrong, and they have went and supported the arguments of CCI, and they asked to pay 591 crores. So what is important for your prelims here? Prelims, you should know which committee has recommended MRTP to be replaced by Competition Commission of India. What is this authority, statutory authority, how many members are there and how it is being present, what is coking coal, and what is nationalization of coal mines. So this is the thing that is important. Just go through it, not more than this is important. Thanks for joining. Have a great day.